Welcome and hello, ladies and gentlemen. I hope everyone is doing well. And due to the pandemic situation, I'm happy to be able to offer this Let's Talk program via Zoom. I'm your host, Mina Abdullahian, and my colleague Jessica Hall is our co-host, and somehow our panelists are all here as a co-host. I don't know what happened to it, but that's the way it is right now. Before going any further, I would like to share some guidelines for this Let's Talk program. And that is the microphones and cameras of participants are muted and turned off. And there's no waiting room in the Zoom webinar. If you leave the room by accident, my co-host and I are not able to let you back in. Please go to the Q&A part on the bottom of your screen and type your questions or comments for panelists and the hosts. Panelists will choose to answer or share your comments for all. Only the hosts and the panelists will be able to read your questions in the chat area. And I am going to talk a little bit of today's program, which is another program on the Let's Talk series. Fresno County Public Library Let's Talk program is a series of programs that provide safe space to learn local and national concerns difficult to talk about, and it is a forum to hear different points of views. Today, our program is about women's, and it's the gender equality. I want to show you the flyer as well. Women's rights are the fundamental human rights that were enshrined by the United Nations for every human being on the planet nearly 70 years ago. These rights include the right to live free from violence, slavery, and discrimination, to be educated, to own property, to vote, and to earn a fair and equal wage. Gender equality is achieved when women and men enjoy the same rights and opportunities across all sectors of society. I'm honored to introduce the panelists of this Let's Talk program to provide more information about the topic. Please don't hesitate to write your questions and on chat and Q&A area. I'd like to also, I'll mention it later, but I was going to say, email me and for any concerns or suggestions for future programs on this topic for the Let's Talk programs. I'm honored to introduce Dr. Kathryn Forbes, who is the chair of the Department of Women's Gender and Sexuality Studies at Fresno State. She has received her PhD in cultural anthropology from University of California, Berkeley. Mrs. Felicia Espinosa is the site director and senior staff attorney for Root and Rebound's organization in Fresno. She focuses on the intersection of gender, race, and the criminal legal system. Root and Rebound's mission is to restore power and resources to the families and communities most harmed by mass incarceration through legal advocacy. public education, policy reform, and litigation. She has received her JD from University of San Francisco School of Law. Dr. Malik Simba was the chair of history and coordinator of African studies at Fresno State. He served on many academic committees and search committee for the history department, Africana studies program, and women's studies program. He served as chair of the history department and coordinated the Africana studies program. Dr. Malik Simba retired spring 2019 after 29 years from Fresno State. There is 2 pages of biography and quotations from Dr. Simba, but I love one of his quotations that I want to share here with you. One of his advices to his students is always study and struggle against injustice with the understanding that the history of the past is dedicated by your actions today. Thank you, panelists, for being here. And I would like to ask one of you to start.
Thank you. Thank you for that kind introduction, and thanks for the welcome. We're really glad to be here. In part, our topic today is motivated by the fact that this is Women's History Month. March is Women's History Month. It began in 1981 when Congress said, let's celebrate women for a week. And then in 1987, they realized that a week probably wasn't long enough, so they gave us a whole month. This month serves as a time to both celebrate women's accomplishments, right, to broaden our understanding of the contributions women have made to the evolution of scientific knowledge, to appreciate their importance in artistic endeavors, and to recognize their role in political movements. But remembering women's labor and genius inevitably involves an assessment of the present. And that's what we're doing tonight, is assessing the present. The act of honoring our foremothers pushes us to ask ourselves, are we doing justice to their memories? What has changed over time because of their contributions? How can we build on their work to build a brighter future for women and girls? Tonight, we want these questions to resonate in our discussion of pay inequality or gender pay discrimination. And we chose this topic very intentionally. Women's economic self-sufficiency, women's wealth is central to our power and our autonomy. Women's earning is central to the power and autonomy of families, to children. Women are often single-handedly raising children and caring for elders without the help of their male relatives. And as the current pandemic shows us, women's caretaking roles, women's work on the front lines of healthcare and in the ag industry quite literally keep our society running. And yet, as we all know, women's wages are very low in comparison to men's. In California, actually, California is one of the better states. California, on the whole, women earn 88 cents for every dollar that a man makes. Oh, excuse me, every dollar that a white man makes. In Utah, which maybe you shouldn't move there if you're a woman, women earn 70 cents for every dollar that a white man earns. And it is a fact that in the states with more robust employment discrimination laws, in those states that have more comprehensive employment discrimination laws, they also have smaller gender pay gaps. So I just want us to think about that for a moment, right? Those states that have more developed laws against gender pay discrimination, employment discrimination, have smaller pay gaps. But as you probably remember from your introductory logic class, correlation does not mean causation. And what we mean by this is that it may not be that the laws are the things that are affecting change to improve the situation for women, but it may be that they are, right? So tonight, we want to merge those two discussions. We want to think about women's wages and employment discrimination, and we want to think about the efficacy of law to reform pay inequality. As probably you all are aware, especially with the recent passing of Ruth Bader Ginsburg, gender discrimination litigation has been the essential tool used by the US feminist movement to combat institutionalized sexism. One of the first things that feminist litigators did was attack those kinds of patriarchal ideologies that were embedded in the law and applied the law in new ways to the lived realities of women. So partly what early feminist legal scholars did and early feminist litigators did was to incorporate gender equity principles into the legal system. In part, this helped shift public opinion about the place of women in society. It helped shift gender power dynamics. Interestingly, and I think what's often overlooked, in all these legal reforms, it was feminist activism that really fueled the reforms. Those organizing campaigns gave feminist litigators the political momentum to try these cases. They also gave them the evidence. If we look at activism around employment discrimination and the organized opposition to violence against women, that shaped all those two feminist movements, or those two feminist pushes, really shaped our early understandings of sexual harassment and fueled our understanding and the recognition of it as a form of gender discrimination. That's a little bit separate than what we're talking about tonight, because we really want to focus squarely on gender pay discrimination and other forms of employment discrimination. So many of these reforms, these early legal forms, really had a dramatic effect on women's employment. The 1978 Pregnancy Discrimination Act provided women with legal tools to fight their employers who tried to fire them when they became pregnant. Some of you may be well aware that employers were free to fire women who started showing. Schools were notorious for this. There were also informal rules that if you had children, you weren't hired. Changing ideas about gender and motherhood, coupled, and this is an important part that perhaps we can also talk about in our discussion, coupled with the very real loss of wages among men, contributed to the employment of women with children, as well as the rise of single motherhood necessitated the employment of women and mothers. So from 1960, right, just 12% of mothers were in the labor force, right? Now, mothers are pretty ubiquitous. In fact, women with small children, the majority of women with small children are also within the labor force now, and just not only those women who are older or those with older children. And yet, and this is actually kind of something that I think we should also just mark, the last significant piece of federal legislation, the last law that was passed to help, federal law that was passed to help women with families and men with families, happened 28 years ago. So there hasn't been much progress on this particular front. Still, right? I want to say that my transition is like there's other stuff that's all even less hopeful. But I don't want to sound totally negative. If we consider Title VII of the Civil Rights Act, right? It states that using racial or gender as distinctions in employment is illegitimate and illegal, right? This was passed in 1964, was the culmination of a great deal of momentum in the US, for which you are all probably well aware. If we consider for a moment what a dramatic impact, we need to consider for a moment the dramatic impact that this had, the passage of this law had. At the time, 80%, right, at the time of the enactment of Title VII, 80% of all white men employed in the US worked alongside only other white men. So to state that more clearly, this meant that white men only worked with other white men as their peers. They went to lunch breaks with their peers. They were judged by other white men. They were hired by other white men. If women were in the workplace, they were usually white and they were usually subordinate. Men and women of color were in these workplaces, but they weren't peers, right? And the white men who were in supervisory roles could go days, weeks without seeing anything other than other white men. Whenever I teach this subject to my students, I always ask them to we always sit on this particular fact for a few moments and think about what are the implications of that, right? What are the implications of having such dramatic racial and gender segregation in the workplace and in the labor market? So one of the things that Title VII did, right, is it attacked this individual level forms of discrimination by employers. Clearly, that individual level type of discrimination was rampant, but it's not as if Title VII was passed and employers said, oh, I see, yeah, now I'll start hiring people of color. Now I'll start hiring women. What really made the difference was collective action from social justice organizations that targeted particular industries and employers for change. Collecting data, pushing the EEOC, creating educational campaigns, pressuring lawmakers. As is well known, the EEOC did not pursue sex discrimination claims until the 1970s. There was very little grassroots momentum to challenge this in the 1960s. The focus was on race discrimination. It is no surprise then that we see in the 1960s and early 1970s, we see a dramatic decline in race segregation among men, right? And it's not until 1970 and 1980, in the 1980s, that we start seeing gender discrimination, the fall of segregation in the labor market among women. From 1980 to 1990, white women made gains, right? But all other groups did not, right? So just to kind of make that clear, I'm starting to be a little bit unclear. 1960 and the early 1970s, Title VII has this impact of opening up the doors for primarily Black men, right? Somewhat for Black women, but mostly for Black men. And then in the mid-1970s through the 1980s, you see women across different racial groups making gains in employment. And then 1980s to 1990s, it's mostly white women, and then everything stops. So there's been very little, over the last 30 years, there's been very little desegregation. So why is this important, right? In this talk of gender discrimination, the law, right? Arguably, the Civil Rights Act is arguably one of the most important pieces of legislation we've had in US history. The reason we bring it up tonight is because the gender pay gap, the number one reason for the gender pay gap has to do with the occupational choices and the occupational pushes that guide women into certain careers. So I thought we could look at a little data. I'm going to share my screen. And let's see if I can share it. If I do, can I share the slideshow? Maybe I can't share it. Maybe I should have put it on the slideshow first, but can everyone see it? Yes. Okay.
Yes.
Okay. So if we look at the gender pay gap, right, this is from 2018, which is actually probably better than it is now because of the pandemic. You see there's a real racial difference in the pay gap. The comparison, for reasons that we can talk about later, but I don't want to take a lot of time up now. The comparison is always full-time employed, right? From the Department of Labor, it's people who are employed year-round, and the comparison is always with white men. So white women nationally make about 79 cents for every dollar a man makes. African-American women or Black women make 62 cents on the dollar. Latinos make 54 cents on the dollar. Asian women make 90 cents, and American Indian and Alaskan Natives make 57. So there's a wide disparity across racial groups in terms of pay. If we also look at the most, God, that's small. Can you all read that, or is that way too small? Is it super small?
Yeah.
Yes.
Oh, okay, let me, oh, sorry. Yes. Let me just sort of say, I thought maybe I could get it bigger. Let's see. Oh yeah, is that bigger? Yeah. So if these are the most common jobs in the labor force, right? Most common occupations for women in the labor force. You'll notice, right, that the second most common is secretaries and administrative assistants. That was the most common in the 1960s, right? Elementary school teachers, customer service reps, first line supervisors, retail workers. Notice, like, many of these jobs are today frontline workers. It's also not very different than it was 50 years ago. The occupations with the largest share of women workers, right? That means that the occupations, they're dominated by women. And this I thought was also really telling. 94% of all secretaries in the United States are female. 97% of preschool teachers are female. If we go down to tellers, 85%, maids, housekeepers, 83%. Then the smallest share of workers, right, is carpenters, mechanics, electricians, construction workers, right? Those ones that are deemed more masculine, of course, have the smallest share of workers. And then if we look at earnings, right? Well, let's just go down to this one, right? With the largest pay gap, right? You'll see, right, that in the financial services, and I think that's one of the places that I think a lot of feminists have been most critical of. Those high-paying jobs actually have the largest wage gap now. So one of the things that you'll see, right, that I think is really interesting is that the kinds of jobs that women are in now are very much like the jobs they were in before the so-called, second wave feminist revolution. So we have to ask ourselves then, if we want to think about the impact of employment anti-discrimination law, right? What's the impact, right? What's the aggregate impact of that law on making the material lives of women better? There's been a robust discussion over the last couple of decades about whether or not law actually serves the feminist movement in the ways that we want it to. The most prevalent criticism warns that pursuing social change through the courts risks, and this is a quote from a leading socio-legal scholar, risk legal co-optation, a process by which the focus on legal reform narrows the causes de-radicalizes the agenda, legitimizes ongoing injustices, and diverts energies away from an effective transformative alternatives. So we can discuss what this means more in the chat. I want to turn it over to the other panelists because I don't want to eat up everybody's time. But I think it's worth us considering, and part of what we're the ways in which the law does work for us. And also, what are some of the good things that come out of litigation? But also, what are some of the ways that that litigation can narrow our conception, right? Our way of thinking of how we achieve gender equality. Okay. So with that, let me turn it over to Dr. Malik Simba, who's going to give us some background, I think, on some of those early legal reforms, particularly around Ruth Bader Ginsburg's work.
Thank you, Dr. Forbes, and fellow colleagues on the panel. I'd like to share with you a citation. Many of you are taking notes. Ruth Bader Ginsburg wrote a very famous Law Journal article in 1978. It's in the Tulane, T-U-L-A-N-E, Tulane Law Review, 1978. The title of that article, Sex, Equality, and the Constitution, by Ruth Bader Ginsburg. And in this particular Law Journal article, she goes over all the cases that set the stage for the response of the women's movement, and also how the women's movement utilized Title VII. Okay, so what Ruth Bader Ginsburg did was to highlight and emphasize, and she has these extensive quotes, that the ideology of women oppression, the ideology of sexism, is a driving force of inequality. And she doesn't really explain whether or not a social movement, anti-sexist social movement, can preempt the law or can change how people view the rights of women, okay? And so I'm only gonna mention two cases of many that she discusses, but one that's interesting because she gives her all these really horrific quotes from Thomas Jefferson to Supreme Court justices and so forth, their view of women, okay? And so in 1908, there's a case called Mueller, M-U-E-L-L-E-R versus Oregon. Very interesting case because this is a period in which there is what we call the progressive movement. And progressivism was a movement by liberal reformers to make law work in a much more equitable way for all social classes. Okay, that's the progressive movement, 1900 to 1921, culminating in the amendment to ensure the right of women to vote. Okay, but begins on the tail end of the Civil War amendments, 13, 14, 15, and then 16, 17, 18, 19, okay? And those amendments all did something to change the social relationships within American society, okay? 13th, as you know, ended slavery. 14th gave Black folk citizenship, and very important, because the Republicans don't like this, it gave them birthright citizenship. That's the 14th Amendment. And if you know anything about GOP politics, you have echoes and a verbiage saying that we're going to change the 14th Amendment because too many Mexicans are coming into this country having babies. And under the 14th Amendment, they are automatically what? American citizens. Because all the ex-slaves in 1870, when the 14th Amendment was passed, they all were born in the United States. So when we read the amendment, it says anyone born or naturalized in the United States are automatic American citizens. So today, the GOP push to change birthright citizenship. Okay, but in that 14th Amendment is predicated the whole conception that we see in Title VII, the equal protection of the law. Equal protection refers to equal rights. That's Title VII. So, Ruth Bader Ginsburg talks extensively about the sexism within American culture and how the sexism is holding women back. Okay, so let me just talk very briefly. Two cases that are interesting. One is Mueller versus Oregon, and that's around 1908. And so the progressive movement, 1900, 1921, is a movement to regulate, use law to regulate society to make it more equitable. So the 16th Amendment, guess what that is? Income tax. Income tax. To take the money from the rich and to spread it out throughout society to have it level. Okay? So Mueller versus Oregon is as with the 16th Amendment, is a regulatory. It regulates income of the rich. Okay. So Mueller versus Oregon is one of the comes out of the regulation of how many hours should capitalists, those who own and control the means of production, why should they coerce workers to work 20-hour week or 18-hour week? So progressive legislation around the 8-hour day is the basis of Mueller versus Oregon. At this time, because we have the rise of the corporate America, 1900, 1921, corporate America develops corporations. And Dr. Forbes mentioned the rise of secretaries. You don't have secretaries and secretary pools until between 1900 and 1921, because that's when you have the large corporate structure developing, where men control at the top and women serve as secretaries at the bottom. And so regulations of work hours become very contentious. Capitalists don't want the law or the state to tell them how long they can coerce their workers to work. So in Mueller versus Oregon, that's an interesting development of a laundry business in Oregon who basically employed only women because they could pay them low wages. And they could make them work 15, 20 hours a day. So with the new regulations, the 8-hour day is very contentious. So the laundry owner in Oregon decided that instead of retaining women to work at a reduced hour per day, because the Supreme Court in Mueller versus Oregon, and this is really connects to the Ruth Bader Ginsburg article about sexism, the Supreme Court says that Oregon can regulate the hours of women in the laundry business, right? Why are women working in the laundry business? Because in corporate America, to go to work as a businessman, you got to have a white shirt, and the white shirt got to be starched. So laundry businesses, you saw an explosion of laundry businesses because white men needed white press shirts to go to their corporate offices. And who are doing the ironing and the pressing? Women are doing that work. So with Mueller versus Oregon, that said that the state of Oregon could tell capitalist owners that they would need to limit the hours of women who work. Now, many people say that Mueller versus Oregon is a great win for women workers, unless you are poor immigrant women who need to work 12-hour day, 15-hour day, just to make ends meet. So you think it's a plus for women to regulate how long they work. But on the other hand, if you're a woman, immigrant woman that has 3 children, 4 children, you need many hours as possible to work to make ends meet. So what happened? The owner of said laundry, per the Mueller versus Oregon, he fired every single woman in his laundry business and then hired men. Because Mueller versus Oregon is specific to women work, not the men. So he fired all the women, they hired all men, and then worked them 12, 14 hours a day. Okay, Mueller versus Oregon. So Ruth Bader Ginsburg goes over that case. The other case that is specific to our colleague here, Dr. Espinosa, Doctor of Law, is the case that she knows oh so well, Myra Bradley versus Illinois, in which the court says, no, women can't be lawyers. Women cannot be lawyers because they are women. And in that case, Myra Bradwell versus Illinois, that case is interesting because it gets back to what Ruth Bader Ginsburg said, that the ideology of sexism is so pervasive, that is what is holding women back. So in that case, as with the earlier quotation from Jefferson and in English common law, Ruth Bader Ginsburg just talks about, look at these quotes of sexism in our culture. And in Myra Bradwell case, Myra Bradwell versus Illinois, they say, hey, the place of women is not in the courtroom. The place of women is in the home. So in Myra Bradwell could not practice law because she was a woman, right? So Ruth Bader Ginsburg talks about those 2 cases. Because we're talking about employment and rights, Title VII and so forth, everyone saw the attack on the Capitol, okay? Out of the 1960s, there is a response of violence against essentially two groups of people, social classes, because of change, civil rights change. Dr. Forrest mentioned the civil rights changes of Title VII that impacted women. White men rebelled against those change, so you have a rise of spousal abuse and divorce coming out of the post-Title VII enactment. And in those spousal divorce, you see a lot of violence. There are major cases in which women kill their husbands or kill their boyfriends over this issue of rights and opportunity in the workplace. And the court has to make a decision of the legal concept, what would a man do in the context of social relationship of abuse and fear? They had to make a pivot to say, well, hey, these women are defending themselves against their abusers and attacker, and they're killing them. So we got to say, what would a woman do? So the whole concept, what would a typical man do? That had to be changed in law to say, what would a woman do? What is the thinking of a woman in a social relationship of abuse? So that's a major development in the post-Title VII development. Social relationship of abuse and anger and fear, and how the courts had to look at what is the thinking of a woman, not the thinking of a man. The other point that I want to share with you, I give you the citation of Ruth Bader Ginsburg Law Journal article, Tulane Law Review. I want to share with you, and you can get it online. When I mentioned the anger that you saw at the Capitol, the anger was not particularly towards women, nor particularly towards Blacks. The anger was towards the seat of democracy, the state, the democratic state, the Capitol. Because these people on the right, their anger has shifted from women and Blacks to the administrative state. Because it is the administrative state that has pushed, I'm talking about white men, they see the administrative state, the democratic administrative state, that is the entity that have pushed them back, pushed them to the periphery. Now, this is how they see it. There's a film I want everyone to look at. You can get it on YouTube, to Google it. It is called The New Girl, Newgirl, The New Girl. Produced under the Eisenhower administration, 1957. This is when we have the, what do you call these, Me Too Republicans, meaning they're following in the footsteps of the progressive Democrats. The we too can be progressive, okay? And these Republicans, the last one, of course, is Senator John McCain, okay? These progressive Republicans help initiate affirmative action. Most people don't know that. Yeah, the Republican Party initiated affirmative action in concert with the Democratic Party. The New Girl is produced under the Eisenhower administration. And it's only a half-an-hour movie, a documentary, reenactment, starring some actors and actresses that you all would know when you see them. I won't tip you off. But you ever seen Mary Tyler Moore? Her editor is the corporate head in this recreation. So what is the New Girl? She's a Black female, 20-something, and Ed Ashner, right? Mary Tyler Moore's editor. He's the head of a corporation. And he has a meeting with all of his CEOs and so forth. He said, hey, we have federal contracts, millions of money coming to our corporation only if we hire and diversify our workforce. That's the anger that you saw at the Capitol. Because as they begin to hire the New Girl, which was a minority woman, a white man is not hired. The anger that you saw at the Capitol has less to do with women and Blacks than has to do with the administrative state that implemented the coercion to corporate America, hire and diversify. If you do not get any federal money federal contracts, the new girl. So the problem with the new girl and with corporate America is that, as Dr. Forbes has said, you got separate lines, or the word is dual, D-U-A-L, dual lines of hiring and promotion. As Dr. Forbes says, most women, 75% of women are in a secretary pool. But with Title VII and affirmative action, the coercion is to push white men aside, unless, yes, white men are literally pushed aside so that diversity and inclusion can take place. So it's something that white man has never even thought about, which is a competitive playing field. A competitive playing field is unheard of until the 1980s. Unheard of. The new girl. I need everyone who's zooming in to look at 30-minute documentary produced by the Republican Party, President Eisenhower, but how to use affirmative action to promote minorities and women. My last point is, there's a book published in 1978. It's by Kathryn DeCrow. And the title is Sexist Justice. That's very important, sexist justice. The subtitle, How Legal Sexism Affects You. And in the table of content, I'm just gonna read you a number of these chapters in this book entitled Sexist Justice, How the Legal Sexism Affects You, Kathryn DeCrow. Chapter 1 is Women and the Law, a study in misogyny. Chapter 2, the 14th Amendment, promoting whose general welfare? I think she's referring to the 14th Amendment, right? That did not include the rights of women to vote. Chapter 4, Money and Employment, a breach of the duty of fair representation. Chapter 7, Estate Law, the power of sex after death. Chapter 7, Estate Law, the power of sex after death. Chapter 9, Criminal Law, free our sisters, free ourselves. Talks about mass incarceration of women. Chapter 10, Motherhood and Abortion, Women and Children Last, L-A-S-T. That's chapter 10. Motherhood and Abortion, Women and Children Last. Chapter 11, The Law of Names, N-A-M-E-S, the Law of Names. Frailty, comma, thy name is woman. I can go on, but we can agree to do about 10 minutes and then have some Q&A. Thank you.
Thank you, Dr. Forbes and Dr. Simba. So I'm coming in at, as we said, I'm, yes, a doctor of law, but I'm a lawyer, so I'm a practitioner, and was going to come and talk about just some cases and the day-to-day of practicing law, and the different ways that lawyers and the legal system and the rights of our community are being enforced, and how we can help out both in courts and as community lawyers and as litigators. But one of, we'll start off, and I want to start off with RBG, right? The notorious RBG, because every doctor before me talked about Ruth Bader Ginsburg. And just to bring some personalization, and in the legal field and for women, the passing of RBG was just felt. I remember when we saw it come in the newspaper, it was just shock, even though we knew that that this justice has passed through so much health concerns, and she just kept holding on. And I think that is some of the burden of being that female lawyer. You feel the burden of your whole community, and for her, it was a nationwide support of hold on to the next administration, and she just couldn't, right? And just that shock. My daughter, my little baby's first, one of the quotes of RBG that she's famous for is that, she's asked, when will there be enough female justices? And she says 9, when there is 9. And I believe in that. I hope that we all believe in that. And, for my daughter's first Halloween, I was Justice Sotomayor. She was Justice RBG. And my husband was our law clerk. And that's what's okay with me. So I want to start with RBG. What I also want to talk about is just cases that I know is in your consciousness because of media, because now we have graphics, but also just to illustrate the importance of the law, but also some of the pitfalls, and why, as a litigator, some of the cases that a lot of my advice and counsel when women are coming to me with things that just, what I tell them is unfair, unjust, this is wrong, and this isn't illegal, and we're not going to be able to win this in court, even though this is wrong, right? And unfortunately, that is part of the legal pitfalls. We're very limited, and we're taking risks and benefits, and I'm going to talk about some of them. Also talking about the inspiration of having RBG and how it a lot of times brings forward legislation that's needed and that changes the law and asserts the rights to where now we're talking about more justice. So just want to share my screen for a couple of, let me see, I also should have made it a slideshow. Okay, so this is the first case I want to talk about, because I think it resonates with a lot of people. When Ms. Powell filed a lawsuit against what was known as the Silicon Valley case, it was a capital firm. She was a junior partner. She was passed up on promotions. There was a huge gender pay gap between her and her male colleagues. And it was a 1-month trial, which is very rare, which is one of the things in court, is that very few cases go to trial. Almost all litigation is settled through depositions, through settlement agreements, through mediation. This is just what happens in litigation. But here, this was the case that was going to trial, and it went to trial, and it was followed closely because of the stuff that you would hear about Ms. Powell. They put her through the ringer, right? She would be able to show that in the world of venture capitalism, golf courses, multi-million-dollar pay, there would be steak houses for lunch and for dinner, and all of the stuff that we think of Silicon Valley, and how she didn't have access to that and how she would complain about it. But on the reverse, they also put her through the ringer, that she didn't play nice with others, that she wasn't a team player, that her job duties were more managerial than actual what it takes to be a good venture capitalist. And she lost. The jury, it was not unanimous, but very, very much found against her. And it was a shock to the community. It was a shock to the feminist world. It was a shock to, I think, a lot of us, because there was also where everybody felt like Silicon Valley is awful, right? Jurors would say that, but because of her performance evals, they said that it wasn't because of her gender, it wasn't because of her complaints, she wasn't the right fit. And that's one of the issues with litigation. It really is a lot of, in these cases that actually get tried, in these everyday, injustices, they look at the woman in ways that we know is coded, right? The personalities of women are taken into effect differently than if you were a guy. Things that we're seeing, that women are seen as bossy or seen as a personality, is seen as assertive, is seen as confidence if it comes to a man. So these little coded things, these implicit biases that are part of the jury, that are part of our judges, that are part of us as lawyers, all of it isn't seen in these cases, because we're really talking about, did this happen because of, her pay, because of gender or not? But the one thing that it did kick off is she, in her book, in an article that she said recently, is this is how sexism works in Silicon Valley. My lawsuit failed, but others won't. And she's right. This is how sexism works, right? It's pervasive. It is cuts by, it's death by a million wounds. Another one that is a great one to profile, and it's from here in Fresno, and I'm sure people have heard about it, is Ms. Rizzo, who fought for 8 years, which shows one of the pitfalls of litigation. Is this was an 8-year case where she filed suit in 2013. She was a math consultant for Fresno Unified Office of Education, and learned in 2013 that a recent male hire who was less experienced, has less seniority and less education, was paid $13,000 more than her. And that's when she filed suit for the gender pay wage differential. That's obvious, right? $13,000. But the problem was that they relied, and what the Fresno Unified Office of Education said is they had to be competitive. The male hire and the other male hires, because he wasn't the only one, but this male hire earned more before, and therefore they based on his last salary and gave a 5% increase. She was based on her previous salary with a 5% increase. But the courts did hold, and again, 8 years, that employers cannot pay women less than men based on previous salaries, because it capitalizes on the persistence of the wage gap, right? In between that time, to get that finding by the court, and it's still in litigation, right? It got sent back to the district court. So like what you and I think of the trial court. Because of her, California passed legislation to prohibit relying on salary history of applicants. So if you were an applicant in the last 2 or 3 years, they no longer ask you as part of your interview, what are you currently making? These are all reasons, because as we know, women have historically been paid less. And that means that for the rest of our lives, we are going to get paid less, because they are being competitive to an underpaid salary. But we were able to pass that law, and this is where that social agenda and where legislation comes in, because the litigation was an issue, right? The litigation took 8 years, and even for the 8 years, it's only for Ms. Rizzo. But she was able, with her story, to capitalize, for people to get behind her and be honest that this is wrong, and be able to change the law. For not just her, right? For everybody in California. Another thing that this also, I think, in some of the pitfalls, is because it's such localities. As one of the things Dr. Forbes said is that, the laws that the states that have stronger discrimination laws on the books are better for closing the wage gap. So here, now that we have this, is another, law that helps women, but other states don't have that, right? So it really is where you're working. where it could be as small as a locality or as big as the state. And what we also wanted to talk about was another way that the social agenda and momentum and where community lawyering and where litigation fails, but where social momentum and organizing and community comes in, right? And where a prime example of that is the minimum wage. If we're able to change the minimum wage, that would have lasting effects and for especially women and women of color, because women do the predominant, have these jobs, right? As everybody has shared before, when it comes to occupations, women are paid less. And one of the pitfalls of litigation is that they look at a similarly situated worker, right? So if we're looking at a minimum wage worker, it's going to be against another minimum wage worker and they're already underpaid. If we're looking at a preschool worker who's 90-something% women, it's going to be based on another preschool worker, preschool teacher who's also a woman, and it's an underpaid job. So if we're able to elevate minimum wage and thereby elevate all other salaries, that will have effects and lasting effects for especially women. Women still are, and this is statistics from 2015. Women still earn 23% less than men for the same work, similar to what Dr. Forbes said. Obviously, vastly worse for women of color, Latinas. We don't get paid as much as white men until October of each year, right? And that doesn't count for the year before that they're still getting paid on. Women without kids earn 90 cents to the man's dollar, and it goes down with every child that you're taking care of, which is another intersectional thing that we talk about and was shared by both Dr. Simba and Dr. Forbes, is when you're caregiving for a child, it's not just you, right? It's you're caregiving for 3 bodies. It's yourself and your 2 children. And our households nowadays are very much raised by single mothers, and this will impact single mothers if we're able to raise the minimum wage. And this is where social movements come in. This is where being able to come from minimally, right now we're talking about $15 an hour minimally will have lasting effects in closing and the gender wage gap and the racial gap, right? Because both people of color and women are in those essential worker frontline minimum wage jobs. Yeah, so I think that to be able just to share as a practitioner, what I wanted to do was be able to share of the pitfalls that it comes to litigation. One, with what they rarely go to court, right? They really, for the everyday kind of jobs, one, they rarely go to court because who has access to the courts, right? Who has access to attorneys? A lot of times when it comes to low income clients, we know, especially here in Fresno, rural justice isn't real, right? There's very limited nonprofit attorneys. There's very limited attorneys doing pro bono work. So your everyday injustices or your potential for stuff that's happening that's illegal, you may not be able to get an attorney because the payout isn't that much, right? Like if it's really based on your wages, if you're arguing and your damages are unpaid wages, then the risk for that attorney to take on that case is high. And there's not enough nonprofit attorneys doing this work that will take on that risk, right? So even just getting access to the court is a problem. What we talked about too is who is the courts, right? We walk into a courtroom, and as we talked about before, RBG said, like, she was the only woman. Now you walk into a courtroom. I remember going into my first federal courtroom. Not only was I the only woman, but I for sure was the only person of color in that courtroom, right? And that was, so the federal courts weren't looking that much different 10 years ago than they were looking when RBG was, in federal court decades ago. So there, the same way as there hasn't been progress when it comes to low wage work and women, there hasn't been as much progress as you would think, even with work just as lawyers, as a woman of color. But I think that there's, especially with the social agendas, what was talking about in collaboration and community and making sure that there's cross intersections, because the law is forever moving and there is absolutely power in having an attorney because we can bring you to court. but also because we're able to work through those agendas and saying like, hey, this isn't going to work. Let's do something else together, right? Let's change the law together. Let's do a social media campaign together. You know, one of the things that Rizzo showed is that social media campaign, that she was, you know, talking about the issue. She, you know, people rallied around her. She was able to change the law. That was not in the courtroom. That was outside of the courtroom. But that one case, that paper trail led to that, right? So it's really about the collaboration, making sure that we're doing it together as a community. And that's how we get better rights for all of us. So we would love to take some Q&As. We'd love to talk about anything that came up or anything that you're thinking about.
I'd like to make a comment, Dr. Espinosa, on your example of you being the only female in the courtroom. The last 4 years has been horrendous for the federal appeals courts. Number 45, also known as Donald J., appointed about 100 federal judges. 90% of those 100 are all white men. Mm-hmm. Now, President Biden will have an opportunity to appoint about 100. I want you to keep track of the diversity of women and minorities that Joe Biden is going to appoint to the federal appellate system. But you got to understand that Donald J., 85 to 90% was all white men. Okay, so, you know, and as Justice Hughes said in 1908, Chief Justice Hughes of the Supreme Court, he said, the law is what the judges say it is. And that's the struggle over not only the federal appeals court, in which 90% of the cases are resolved, but the conflict over Supreme Court appointees. And if the law, if you think a law is an instrument to use for your own individual rights, let's say, then I think the judge or the justice can use law instrumentally one way or the other. And that's why it's a tragedy that Thurgood Marshall was replaced by Thomas, and Ruth Bader Ginsburg replaced by Barrett. But the reason why you have these specific conservatives replacing liberals is because you have a philosophical approach. The law, if it is in the hands of a liberal versus a conservative, the law can be interpretive to the benefits of one person's rights and not the other. And that is the clash and the contentions over federal appointees. And that's why Donald J. appointed 90% of federal judges look just like him. Joe Biden is not going to do that. Keep track of who the diversity that Joe Biden will appoint. But at the Supreme Court level, those two cases that you know so well, Thomas versus Thurgood Marshall, and Ruth Bader Ginsburg versus Barrett. The other point that I want to make, which is very important, individual rights is a driving force of Western law. However, all Western societies are grounded in class relationships, grounded in gender relationship. I didn't use the word individual, did I? Gender relations and class relations. So what does individual rights mean? In San Antonio School District versus Rodriguez in the early 1970s, there was a culmination of the Supreme Court saying, we severely restrict any litigation that has to do with class or social class relief We're not trying to rectify social class relationship. That's San Antonio School District versus Rodriguez. So the whole idea of individual rights is very destructive because we don't live as autonomous individuals. We live in social relations of class and gender. That's why we're at this topic, gender in the law. Gender is a social relationship of hierarchy. And whoever controls the law controls that social relationship. Per San Antonio versus Rodriguez, we're not going to entertain any more class action lawsuits. Listen to that phrase, no more class action lawsuits. So the court understands that it is not about individual rights, it's about class action or class rights. Study San Antonio School Board versus Rodriguez to understand the dimension of class relationships.
Yeah, so I mean, I think in terms of how it relates, well, going off the class, I think, you know, it goes back to the occupation that we were talking about before, right? Being able to raise wages, being able to raise salaries, being able to unionize, all of those have a benefit, including for gender, but has a benefit for us as a community, right? Unions, a unionized workplace has a better work for the workers, regardless of who they are. And yes, for white men, white women first, and everybody else, but a unionized workforce is really based on that social class, and it benefits gender, right? It benefits women. So I think that kind of goes in line to what we were talking about in terms of raising it, and making sure that the social agenda, you know, includes making rights for people. I think that when it comes to your question about who Biden appoints for judgeships, that also goes to make, it's not just lawyers who are keeping track now, right? It's who Biden, who himself is a lawyer, goes and appoints other lawyers. You know, part of our government, part of our democracy that you were talking about is we have checks and balances. So even if the courts does something wrong or does something in our favor, a conservative president undoes all that, right? Or the other way around with Biden, can try to undo some of the stuff that was done by, 45. And that's where those checks and balances come in. And interesting enough, lawyers are in all of those checks and balances. And those are other ways I think that, us working together as a community, where it's not just the courts that are going to be able to enforce our rights. Anything else?
Dr. Forbes, your graphic, I think, parallels my point about how in the post-Title VII period, the biggest problem is how the federal government and federal power, and that's why the federal bureaucracy is so hated now by the extreme right. The federal government had to figure out, per your graphic, Dr. Forbes, how to eliminate the DUAL, the dual lines of hiring and promotion. That is a tremendous problem.
I think that, one of the interesting things I think about the passage of Title VII was that it was huge because so the federal government was already enacting Title VII in federal contracting, during the Second World War. Right?
Okay, and that is the movie I want everyone to look at, The New Girl.
Yeah,
but it's exactly your point.
Yeah, so they were already doing it, and so they extended.
1956.
Yeah, so they extended to private industry, and private industry went bananas. I mean, private industry did not want, not just, the corporate, corporations didn't want any intrusion, but also it was some kind of like this capitalist ideology that we are, freedom means the freedom to do whatever we want to in the workplace as well. So it was huge to start regulating the workplace in a way. And I think that there was tremendous amounts of pushback. And the only way that, and in fact, the law was kind of, was not extremely, it wasn't an aggressive law. What became aggressive was the establishment of the EEOC to enforce it. And then the EEOC was actually much stronger in the 1960s than it is now. So the EEOC was going out and auditing places, was auditing industries, was auditing different corporations, was using all of these models of personnel review and personnel systems that were anti-discriminatory, that were actually, developed by corporations like GE that had federal contracts in the first place, that were creating weapons, right? That like the weaponry that the most of us who have worked in large bureaucratic organizations with huge HR departments, all of those most of those procedures have their roots in GE and these other corporations that were producing weapons, as well as in actually in union stuff around the Federal Labor Board. So I think that like I kind of take it for granted that that of course we would abide by these anti-discrimination laws, but when you think, it was huge in the 1960s, as you're pointing out, right? I mean, people didn't want that intrusion.
Well, I want to talk about the Me Too Republicans and the 1956 Eisenhower produced documentary, The New Girl.
Yeah.
How to implement diversity, because we need the federal contracts. Right. We need federal money.
Right.
Anything philosophically, morally right about diversity, it is coercive. If we don't hire the new girl, we don't get the federal contracts. So we talked, I'm doing this interfaith scholars workshop, which talks about the morality.
Oh yeah, I saw that.
Social morality within our culture. But I think philosophically, you have a philosophy of morality and what is right and do the right thing. But one of the least known presidents that initiated this type of moral imperative to do the right thing occurred in 1945 with the Fair Employment Practices Commission. Okay, the FEPC. Now, even though that was under Franklin Delano Roosevelt, and that was coercive because there was going to be a big, massive march on Washington, and he didn't want 30,000 Black workers marching on Washington to protest discrimination in the railroad industry. So the FEPC, the Fair Employment Practice Commission, begins in 1945 under a Democrat. And so,
but there was like tremendously more resources put into trying to root out discrimination and incentives. Now it's just, I think as Dr. Espinosa is pointing out, is that it's a complaint-driven system. So it's not to put it another way, like what I tell my students is like, imagine if the EEOC was like the EPA, right? The EPA, you have to prove that what you're doing is environmentally sound. What if you as an employer had to prove that, hey, I'm being fair and not discriminatory? And right now we just don't have that, So, and it could have gone that way, right?
Well,
it could have gone that way.
You don't have leadership, basically. The one least known figure in the change of transforming America to a more inclusive and diverse America is Harry Truman. And you ask practically any American walking the earth today, who is Harry Truman? They don't know. He integrated America. He diversified America. He integrated the armed forces. He implemented and took the FEPC to a higher level. And his program was not the New Deal, but it was a FAIR, a fair deal. Harry Truman, but no one knows. And when Eisenhower did his affirmative action with the New Girl, he says, me too, we can do affirmative action better than Harry Truman. So this whole idea that led to Title VII begins with Harry Truman. Harry Truman was moved to be a big proponent of integration and justice, social justice, because of a young Black soldier who was returning home to Atlanta, Georgia, and in uniform in 1945. And a white supremacist policeman didn't like to see a Black man in uniform and beat him so severely he lost his eyesight, couldn't see. When Harry Truman heard about this young corporal being blinded by this white supremacist policeman outside of Atlanta, he said, we're going to integrate the armed forces. We're going to make equality the driving force of who defends our nation. And that whole idea of equality and diversity led into employment and many other areas of American life, and led to Title VII.
So it looks like we're about time. Is there any questions from the audience? Anybody want to have departing words? No?
No. Well, before my departing word, what I did want to say is kind of just to what you guys were talking about in terms of like complaint driven. What I also just want to shout out is all the work that's happening right now that is transformative. That's not the law, where employers are having to prove themselves, right? And this is where those social movement, those organizers, that campaign is making the changes that our very narrow legal minds can't do. This is where employers are saying like, hey, we are hiring women, we're women owned, hire Black entrepreneurs, do this, do that. Like, those are those movements that are making huge traumatic changes in a way that the courts haven't been able to because of that complaint driven. And I think the last couple of years have very much shown that, and want to shout that out.
Yeah, and Dr. Espinosa, the word I think is a resurgence, and Dr. Forbes knows about the first wave, second wave, third wave. These waves of energy and movements, right? And lately, the death of George Floyd has created another wave in which Dr. Espinosa is talking about, in which people are more conscious and sensitive about the destructiveness of racism and how it must be faced, not only in the social sector, but in the employment sector. It's the type of social violence, as Dr. Ford says, unequal wages is a type of violence that hurts people, that destroys people's lives. $13,000, as Dr. Espinosa specified, that's a big swing in the Silicon Valley case. And I think Mr. Floyd's murder has re-energized a new wave of reform.
So there is one question, maybe our final words can be responding to that. So one of the questions was, other than voting and donating, please check out rootandrebound.org for any donations. What else can we do to combat inequality? I think that part of this new wave and a lot of what we're doing right now is, I think, self-reflection too. So I do think that one of the things that we talk about is heal yourself and you heal the community. So making sure, where are you yourself a part of that inequality? Where do you have biases? Where have they shown up? And how can I change that? Be that with gender, race, ableism. Like, there's a lot of ways that we don't even realize that we're perpetrating inequality. And I think that that's a great place to start, and a place that can be started immediately.
I agree.
Anybody else? Any parting words?
I'm going to jump in. Dr. Simba recommended some movie, a movie that I'm really, really interested in watching it, and also a book. Beautiful. And now I want to recommend a movie that it's you can find it on a canopy. If you have a library card, you can go into Canopy for free and watch I Am a Girl. It's a documentary about that paints a picture of a reality of being a girl in 21st century in Vietnam, in Cambodia, and in Afghanistan. Interesting.
I Am a Girl. Thank you.
I Am a Girl.
Thank you.
I can't, I hate to say goodbye to everybody, but thank you, Dr. Espinosa. Thank you, Dr. Forbes. And thank you, Dr. Simba. I am so honored to have you as a panelist. I learned a lot, as I expected. And thank you for all the participants. Please do check our website, fresnolibrary.org. And if you have any recommendations for the Let's Talk series program, don't hesitate to contact us via the website, or just call me directly. My telephone number is 559-600-6299. Thank you again to all the participants, and good night.
Thank you very much. Good night.
Thank you. Good night,
Ciao.
everybody.
Good night.